Good afternoon, everyone, and welcome. Thanks for joining me today. My name's Christy Miller. I'm a partner in the Workplace Relations, Employment and Safety team here at Clayton Utz. And before I start, I did want to pay our respects to the elders of the lands on which we meet, past, present and future. And as a webinar on the lands on which we all meet today and wherever you are. I would love to sit and have a chat with you all and catch up and engage in some pleasantries, but we simply don't have time today. So much has been happening in the employment, industrial, safety and governance space in the last 6 months, 2 months, in the last 2 weeks, so much has been happening, particularly around these issues of vaccinations. You know, do we make it mandatory? Do we make it voluntary? And casuals as well. We have a new High Court decision that we want to talk about as well. So everyone will be forgiven for not being able to keep up with the frenetic pace and the developments as they're occurring. But that is why we are here. And I don't want to waste any time getting down to tin tack. So I do want to quickly jump over and introduce our guinea pigs, our panel today. We have Heidi Cray, Hilary Searing and Shane McCartney, all partners with me in the workplace relations practice at Clayton Utz, and we are going to ask them the hard-hitting questions today. So there are a range of topics that I get the privilege of asking my partners questions on. You'll see that I'm sitting in a different room. That's not just COVID related, that's for my own safety as I ask these questions. But I should say as well that there is a Q&A function as part of the webinar. Please feel free to pop your questions up there. I'm going to try and get to as many as I can. I do want to keep the conversation moving across the variety of topics that we have. Those that we don't get to that I think will be beneficial for the broader audience, we'll put together a little Q&A package after this is over and shoot that out to our audience today. So, to save up your questions, put them in that Q&A function, but let's dive straight in, and there is no rest. We are starting with, is it the hardest, is it the most important, or is it just the most interesting topic that we have, I think, today? This issue of vaccinations. Now, look, the government, and even in publications that were released last night, the government is steadfastly refusing to indemnify employers for encouraging or requiring vaccinations in their workplace. Lots of employers, however, are really keen to jump on that bandwagon. I see Minister Cash is still saying voluntary is best. But the Prime Minister, Shay, I think, has given a little bit of wiggle room there. He's come out and given, I think, a little glimmer of hope in relation to potential relief from prosecution. Can you talk to us a bit about that, Shay? Tell us what's possible. What are the risks for employers when they're going to go down this mandatory or even this voluntary vaccination space?
Thank you, Christy. Yeah, easy question. Not too many areas of law to traverse there. So obviously it's extremely difficult for, I think, employers, government and individuals to work out where their path lies, given that there are so many competing areas of law and, I guess, areas of public policy and tensions between individual interests and protecting the vulnerable, but also the employer's right to protect their business and to deliver reasonable and lawful directions. The Prime Minister has indicated that he was exploring giving an amendment to the regulator intent to allow for employers not to be prosecuted if they are unable to provide a safe place as arising out of COVID. But that is very, very difficult in terms of, does it give us a glimmer of hope? Firstly, it's state legislation, so whether he would actually be able to deliver on that in any event other than through the federal regulator. And secondly, apart from being, I guess, quite a difficult approach to have a regulator that is not applying the law as the law is written, it doesn't change the law. It doesn't actually change what is probably the most difficult aspect, which is how does an employer who perhaps wants to vaccinate, it has other challenges other than just risk of prosecution, including the desire to keep its employees safe. So I don't think it's a solution, and maybe only gives a very small glimmer of hope. But I guess the key is really about knowing on what basis we're thinking of offering either voluntary or mandatorily. Are we talking about managing risk, or are we talking about managing business suppliers? We've seen with SPC's commentary.
Okay, thanks, Shade. That's really interesting. And you've mentioned SPC there, one of the first employers to come out and indicate that they are rolling out a mandatory vaccination package. We've seen now Qantas do it as well. I think Alliance Airlines have also done it. Hilary, talk to us a bit about what Qantas have done, what other employers should or could do in this space. We saw Qantas use a survey to test sentiment. Should we be gauging employee uptake as a starting point for any type of voluntary or mandatory vaccination requirement?
Yeah, thanks, Christy. I thought what Qantas had done was really interesting, and I think they mentioned they'd surveyed 22,000 of their workers, and I think notwithstanding the voluntary nature of the survey, consultation obligations exist for employers under both workplace health and safety laws and under various awards and enterprise agreements that might cover your workforce. So if you were thinking of introducing such a mandatory vaccination policy for COVID, for example, consultation, I think, is a really good start. And bringing people on that journey with you. I think Heidi mentioned just before we were starting today's session that I think 80% of Qantas's people that had been surveyed had actually already had at least one jab or were signed up for it. And I think that is a huge part of of where we're sitting right now in the community piece. But being able to bring your workforce on the journey with you, whether that's I think whether you were to mandate the policy, and we can talk a bit more about what employers might want to do if they were going to do something like that, or even if you were to have a voluntary program, making sure that you're aware of the sentiment that's existing within your business, I think is a huge part of sort of that winning the hearts and minds of your employees and being able to bring them on that journey with you. I think it would make either a mandatory or a voluntary program that much easier, and notwithstanding whether or not you actually have to consult legally. I know that the TGA has issued some guidance, for example, in terms of I saw this morning, I think Telstra is offering an incentive program now. I think they're offering a $200 incentive program for each of their workers who are voluntarily going and taking up the vaccine. And that brings, a whole range of other issues in terms of incentive programs. I know the TGA has issued some guidance on that. So I think it is a vexed space for a lot of employers, but there are things that we can be doing, whether you're choosing to look at going down the voluntary path or whether you're looking at whether you're able to mandate it in your workplace, but bringing the people, your employees with you on that journey, I think is a huge part of it.
Okay, and Heidi, so say we've started down that journey with we're introducing a program, be it either voluntary or mandatory, and I'm happy to hear from you about what you might prefer in that space. But if we've got a workforce that is partly vaccinated, maybe we've been successful, maybe we've hit the magic 80% milestone for vaccination, and 80% of our workforce is vaccinated. 20%, however, are refusing to be vaccinated for a variety of reasons. And then we have a percentage of that workforce who are now refusing to attend at work of the vaccinated population because they feel unsafe or unprotected by the unvaccinated population in the workplace. What can we do? I'm just throwing out the tough ones there for you, Heidi, but what do you think we should do, and what some steps that employers should be taking, either to avoid this situation or to deal with it as it arises?
I think you've just embarked upon every employment lawyer's life right now, because inevitably those questions are being asked a lot. Unfortunately, in this space, reflective of the Prime Minister's comments and what's happened in the last 24 hours, no business is necessarily the same as every other business. If there has not been legislative intervention for healthcare workers and or aged care workers and other steps which might give rise to balancing those obligations, the voluntary versus mandatory vaccination piece and engaging with your workforce, just as Hilary said, is going to be critically important to the defensibility of ensuring that that workplace scenario you just outlined is able to be addressed. An employer can lawfully and reasonably require an employee to come back to work if it's put in place appropriate steps to ensure the workers' safety, understanding why the vaccinated workers are not wanting to come back and what steps are actually there, what type of workplace we're actually addressing. Before vaccination even came on the scene, of course, we were all managing appropriate PPE and other health requirements to ensure that businesses were able to function. All of those questions will remain, but the risk of adverse action, discrimination, increased complaint and breaches of consultation obligations will all be there in the big mashup as we try and resolve that problem. You asked the question, what would I prefer, mandatory versus voluntary? I think that there's a lot of vibrato about mandatory, no jab, no job. And the reality is we've been having flu vaccinations and doing a variety of very similar things for a long time. The vast majority of Australia has been a very vaccinated population. The issue of understanding the fear, understanding the accessibility and understanding the time frame all becomes part of introducing an appropriate and proportionate policy. Keeping communities safe, where your workers interact, how you get disclosures and how you roll out a policy may very well still be a condition and requirement of employment, but you don't have to use the evocative word of mandatory. You have to be fair, reasonable and engaged and be clear about the risk assessments that you've undertaken and the role that we all have to keep our workers safe, but our community safe. And with some of the incidents that have occurred across the country in recent times, the travelling, the declaration, the impact of how inadvertence can shut down a state, the reality is that it is going to, I think, become easier to have those conversations and roll out vaccination policies with proportionate and appropriate explanation around managing those who can't and won't, and the medical assessment and impact against the inherent requirements of the job. All of that law is actually the same as it was before. It's just the impact that there's a heightened degree of urgency and community safety, which is now going to likely fall in favour of enforcement where it's reasonable and proportionate.
Okay, thank you. I think that's some real food for thought there in terms of how each particular business develops their own policy around vaccination, either encouragement in line with TGA guidelines, thanks Hilary, or mandatory to meet the needs of the business and the operational requirements. We could talk about vaccinations, the requirements and how to implement policies around incentivising staff members to take vaccinations or otherwise, and what is required there, or the risks around requiring vaccinations and what type of businesses should be looking at mandatory policies for a long time. And I'm happy if you've got some further questions on that space to pop them in that chat function and we'll come back to it as we can. But I want to really now move. Sorry, Heidi.
Can we just, mask off. I just wanted to flag, we are currently 35 out of 38 of the OECD countries in terms of vaccination. There is a fantastic blog to identify that 25 November is the date that we are theoretically going to reach that 80% that you referred to before. The ACTU has released its statistics that they are looking for vaccination leave to be provided, additional leave. 20% of people who have been vaccinated have had an impact which has caused them to take personal leave or need to take additional care. 1.6 million people have already had some form of vaccination leave. In addition to the incentives that Hilary was mentioning, there are a whole range of other good things that are coming out that could help encourage and move towards addressing some of these more difficult issues as the country gets back on its feet in response to this.
Thanks. I wanted to move to the next big topic, casuals. And I know a lot of the hype has been around casual conversion and how does it work and what are the timeframes, and we will come to that. But I did just want to really quickly touch on the Rosado decision. We all need a High Court decision to talk about, or maybe that's just me. And what are we talking about here? We're talking about the WorkPac decision where finally WorkPac got their verdict that Mr. Rosato was in fact a casual employee, despite the 6-month rosters set in advance, despite the regularity of his employment. Hilary, this case to me had all the hallmarks of the AMCOR policy redundancy High Court decision where, and this is the role of the High Court really, isn't it, to look at the facts and to apply it in a broader context and to look at potentially that policy implication there. But talk to us about the impact of this decision and what do you see it doing to the work employers have already embarked on in terms of assessing casual engagements? Do we stop? Do we keep going? What are we doing?
Thanks, Christy. And yes, I love a good High Court decision. So I think the Rosado decision is a really important one. And as you said, it has all those sort of hallmarks of sort of being such a pivotal case for employment law moving forward. And really what I took from the judgment was the intense focus that the High Court brought on the contractual nature of the relationship and really focusing and honing in on that and what the contract actually said about what the nature of the relationship between Workpac and Rosado was. And a lot of people have sort of wondered whether the Rosado judgment was a bit of a not nullity, but a bit futile because the decision, the legislative provisions had already come in place. So the ones that you were talking about there, Christy, in terms of the Fair Work Act's amendments that had brought in some legislative assistance to business and workers in terms of how do we frame up those casual contracts. So to that sense, I think a legislative solution has already been proposed, but I think Rosado still has an enormous amount of impact because it answers that sort of really that double dipping back pay question, which I think is a huge one. And the commentary that the government was putting forward at the time of Rosado is I think that there was about a $38 billion potential underpayment sitting out there in the industry. And I think that Rosado then resoundingly answers that question to say that, no, we don't have a double dipping problem here for industry. But as a whole, but your contracts are still going to be incredibly important. So I think to your point, employers are still doing that good work, I think, and you'll still need to keep doing that good work. You still need to be looking at your contracts, making sure that they frame properly, making sure that we really are taking the benefits out of that new legislation and making sure that the 25% casual loading is really called out separately, make sure that it's all covered and make sure that you really are addressing that risk. And then I think making sure that your contracts take advantage of what Rosado is setting up to show that it really does, that you've fully and squarely considered that nature of the relationship and ensure that it is casual at the outset, and that's what both parties have in mind and that's what you've set up. And I think that will really help moving forward in terms of this casual piece, and as I said, with the double dipping aspects, although I note that the Adano law firm who does a lot of class actions have said that this is not dead in the water and they think there's an enormous amount of possibilities still coming out of Rosado that they can take forward. I'm interested to see how they do that, Christy.
Me too. Thanks, Hilary. I think that's a good tip. So we've got to be looking off and leveraging from both the Rosado decisions, some of the comments that they've made there, also the legislation that's in place, making sure we're shoring up those casual employment contracts now and into the future. But that doesn't deal with, Hayley, I'm coming back to you on casual conversion, this casual conversion issue. So we've shored them up, we've made sure that they are casuals in name and body and substance. The casual conversion rules still apply and they're all over the place. What should we be looking at and what time frame are we working towards? Talk us through it.
Well, the legislation that was introduced in March gave employers a transitional period. That transitional period is coming to an end on the 27th of September. There is a period of time where once a determination is made in transition, you have 3 weeks to have made your offer of conversion or declined an offer of conversion and met and explained the reasons why. The impact of where everything is right now is obviously different again for different employers. Large employers that have a lot of casuals are coming across a broader and more complex issue to consider, particularly large employers with multiple awards or enterprise agreement obligations. The full bench of Fair Work in June made some observations that the casual interaction now between many awards is inconsistent and less beneficial than the national employment standards. As a result, you have also, following Rosado, a number of people going, what does this mean? As Hilary aptly and appropriately says, it actually reinforces both the legislation now, but also that contract is king, and that how we characterise our contracts is and will remain important for the meeting of the thresholds under the Act. But it gives us also some comfort for the historical reclassification dispute issues that arose with the were they actually paid and engaged as a casual if you meet those tests. So relevantly for where we should be right now, we should be well and truly on the way, if not having made a determination, because we are running out of time to meet that by the 27th of September. We need to be looking at, as I'm sure everyone is across, the 12 months of engagement. If you're using your contracts properly, that is an issue which will be able to help manage the administrative burden of how you actually characterise your contracts and whether the 12 months is met. You then need to be looking at have they been regularly engaged? They are different tests than the previous unfair dismissal for regular and systematic. And one must think when you look at the explanatory memoranda that there has been thought and judgment to why the tests are actually different and the emphasis on the tests. After the regular pattern of work, that pattern of work and regularity for 6 months must be capable without significant adjustment to sustain a full or part-time position. And then, of course, there's the reasonable business grounds. Those will be the grounds that will be fertile for dispute and complaint and the lack of parity of treatment issues that might arise against the genuine operational reasons, whether or not the position was actually a maternity leave replacement position, pulling into other language or engagement issues of inconsistency that employers might have, whether or not there's funding linked to that position, whether or not the work dries up and won't be required, whether or not economies of scale should be considered, or importantly, whether or not terms and conditions of law or enterprise agreement require recruitment decisions to be made in particular ways. All of those things are going to need to be very carefully considered and documented as you go through your determination. If you are an employer with a large number of casuals, you're going to have to get your processes streamlined because, unfortunately, it doesn't stop on the 27th of September. It's an ongoing assessment. So from that perspective, people, casual conversion, it's not sexy, it's not exciting, it is important. We do need to see it through.
But on that note, thanks, Hattie. What is sexy? Wearing masks. Thanks.
Thank you.
I'm not just saying that. There's relevance to that comment. We've had a question about masks. So, Shay, I'm going to move to you. I'm going to ask you this question because we are backtracking slightly in relation to the COVID stuff, but it is a PPE question and you're the queen of our PPE. And then I'm going to come to psychosocial hazards because they're all in the same bucket. So the question is, what are the thoughts on frontline workers notifying an employer that they have an exemption to wear a mask, and what lengths can employers go to request information in relation to that exemption?
So there's two aspects to it. The first is, of course, the compliance with the health directives. And if a workplace is simply enforcing the compliance with the health directives, then similarly they would be checking to see whether any exemption is consistent with that health directives. And for example, a medical certificate, the health directives set out a list of medical exemptions and the grounds for those exemptions. And I think it would be reasonable to ask for evidence of that exemption. But other workplaces go further than the health directives and, for example, may require masks to be worn even when a health directive doesn't require masks to be worn, and that's part of their health and safety controls. And that then goes back to the reasonable lawful direction, setting out whether or not that is a reasonable response to the risk assessment that's been identified in place. And the wearing of masks is quite a tricky one when you're dealing with it as a control rather than compliance with the health directive, because if you're saying that it is PPE, then there are very strict rules under the legislation about PPE, including that it must be fit for purpose, you must supply it, you must be trained in the use of it, and it must be fit to actually control the risk. Now, we know that only certain masks worn in certain ways with certain protocols for its use and training actually remove the risk of COVID, and therefore an employer needs to be very clear on what its policy is and the grounds on which it's enforcing masks. But yes, I think it's reasonable to ask for a medical certificate, but they do have to know if they're taking action post that, on what basis are they actually enforcing the mask wearing.
Okay, good answer. Thanks, Shay. And I'm going to stick with you so you can keep that mask off for a minute because we're talking about psychosocial risks.
It is one of the exemptions to
drinking and talking for clarity. Yes. Psychosocial risks. And I think this is a COVID-related topic as well, because psychosocial risks, I'm seeing an increase in these risks for employers in terms of how employers can manage those risks, because we've got a greater proportion of the workplace working remotely from home, in a more unsupervised environment. Perhaps they're working under different conditions. Perhaps they're working harder. What do we need to know about psychosocial hazards or risks, and what is this new code of practice that employers need to be aware of, and how is it different to what we are as employers already or should already be doing?
Thanks, Christy. And I think it is a very difficult area, firstly because the word psychosocial is very difficult to say and doesn't really mean a lot to a lot of people. I had one client say to me that they thought it was psychobabble. And I explained to them that, no, it was actually a very serious area of risk to their workers, and they had to understand it. A lot of employers are calling it mental wellness instead of psychosocial hazards. I think people understand that better. But you're absolutely right. We've always had an obligation to ensure the health and safety of our workers, both their physical and their mental health. And as we've seen this increasing risk, I think, to people's mental health, we've seen increasing regulation in this area. And we saw when the industrial manslaughter laws were introduced in Victoria, the minister went so far as to say that her view was that if a worker was bullied at work and they committed suicide as a result of that bullying, that the industrial manslaughter laws could apply. Now, that's a very strong statement and perhaps a long bow to draw to see how those laws, how you could ever prove that. But it goes to show, I guess, how seriously it's been taken. And so we've always had the obligation to manage it, but we haven't had a lot of guidance about how do we manage the mental health aspects of our obligations. And it is tricky because you are cutting into people's personal individual characteristics and also their personal life. So where does the risk begin and end, and where does what we can do begin and end? So New South, firstly, the national guidelines were released. From there, New South Wales has introduced a code of practice. So it's not mandatory in Queensland or in other states yet. Western Australia has, but it is mandatory, or you have to comply with it in New South Wales or achieve a standard as high. Western Australia has just introduced for discussion its code of practice, and I would expect that the other states will follow very, very shortly, given the seriousness of this area. As well as that, we have an Australian standard which talks about how to manage those risks, and if you're ISO 45001 certified, then the Australian standard on managing psychosocial hazards fits right in very neatly with that. So it's meant to give guidance as to how to do your risk assessment, identify controls, and then implement those controls over those mental health risks and hazards.
Mm-hmm. And I think then, moving on then to a topic, but a very related topic when we talk about sexual harassment, where, Shay, you're talking about managing mental health risks in the workplace and having in place those assessments and complaint procedures to enable organisations to be able to deal with that. That certainly fits and is required in the sexual harassment space, and certainly sexual harassment complaints and concerns being brought against individuals within organisations and then the employers themselves. This is an area that's certainly in my practice, and I know that this is shared with my partners, is seeing no signs of slowing down, unfortunately. It's on a very steep trajectory. And part of that, I think, in response to that, I think we've seen that Respect for Work report come out. Hillary's Safe Work Australia has released its first comprehensive guidance in this space on preventing workplace sexual harassment. So, Hillary, maybe I can get you to take us through that guidance a little bit. Just the cliff notes, please. We just keep it tight. I know we can all talk, but really my question, give me the highlights, but also let me know, does it change the way, this guidance, does it change the way that employers should be responding to sexual harassment complaints?
Christy, I think it's an important aspect or assistance to help employers respond to what, as you said, is a really increasing issue. I think the guidance itself is quite lengthy, but it includes a lot of practical information and examples of risk factors and controls to enable people to be able to deal with this issue. And I think the way I see that the guidance material sitting is it's just really hitting it front and centre and showing that sexual harassment is not just an HR or an employee grievance issue, but it's actually a workplace health and safety issue, and it's a matter that is increasingly becoming prevalent and being dealt with by regulators in that space. So it's exactly to Shay's point about the psychosocial hazards. It's the same sort of guidance material that helps you to be able to identify the risks, assess the risks, and implement control measures, and then verify their effectiveness. And it talks, what I liked about the guidance material, Christy, is it gives some really good examples about risk factors and some of the things I perhaps hadn't even, particularly thought about or given enough attention to over time. And they sort of really call out some things, for example, power imbalances, workplace where one gender holds most of the management and decision-making positions, what can be the impact of sort of bystander behaviour where, even relatively low-level sexual harassment or inappropriate comments are sort of tolerated. Things about how working from home can actually produce, which I think is a huge issue during COVID, obviously, can actually create an environment where there's more potential for that sort of covert sort of sexual harassment or online harassment to occur when people might be more isolated and alone. And some of the things that it gives you is some really, some control measures, and it does recommend a very proactive approach. And one of the things that I think is going to be an interesting one, and I think you're going to be talking to Hayley about shortly, is about how do we, they're sort of recommending taking a wholesale sort of investigative approach within your business proactively and sort of almost surveying your workers and encouraging anonymous complaints and things like that. I know from an employment perspective that can be incredibly hard to investigate those things and to actually deal with those matters, but it provides, I think, a very wholesale guide to how we can address what is an increasingly difficult area for business and for people moving forward to make sure that this kind of behaviour doesn't keep happening.
Yeah, I do want to drill down into that a little bit more in terms of how can employers proactively take steps in this space, and you're saying that the guidance is useful and it provides us with some tips on different areas to risk assess and to identify potential hazards arising or potential weaknesses within a business that we can look to rectify. But the legislative changes, Hayley, that are being proposed, and I'll just pivot to Hayley now, the legislative changes that have been proposed following the Respect at Work report, I really want to understand whether they are going to make a difference here. And I mean, we've seen the recommendations that have been adopted. I've seen things like the importance of now and the amendments to legislation which says we're going to ensure that sexual harassment is considered serious misconduct. Now, I don't know about you guys, but it was always serious misconduct to engage in sexual harassment. The issue is how to prove the sexual harassment. We are dealing with a very high bar to make those findings of proof in any type of investigation that you're undertaking. in looking at potential allegations of sexual harassment. That is the real crucial issue for me. Does the legislation give any more power to employers in terms of their ability to investigate or how they can respond to allegations of sexual harassment to address these concerns and act in accordance with the guidance that Hilary has told us about?
As a female partner in employment law, speaking with female partners of employment law, with the legal profession that has significantly fallen down across the country, both at judicial level and in various of the law societies of the states and territories, I too would say that it has always been serious misconduct, but we are all disappointed that from 1992 and earlier, depending upon what state and jurisdiction you are in, sexual harassment has been unlawful, yet we are still having these conversations. So I do think, as Hilary was saying, from the aspects of the movement of additional guidance, that it is reflecting, as has been so many other developments, in a broader and expansive impact of ensuring that employers and regulators have rights and responsibilities that are capable of being enforced. I would think a good employment lawyer would say this is a victory for common sense, it's not necessary, but it will get a lot more attention when somebody does have a sexual harassment stop order, as the legislation will be amended to that. A sexual harassment valid reason for serious misconduct put beyond doubt that it is. Will it help us clarify what is unwelcome conduct of a sexual nature? Again, depending upon where you are and in what jurisdiction it might be pursued, perhaps not. And this is one of the biggest tensions around the ongoing development of law versus the impact that culture, behaviours, feedback, to the points that Hilary was promoting. Maybe it's just because I'm old and I have seen history repeat itself time and time again. In 1998, when they introduced in Queensland the guidelines for workplace bullying, all of the same things were identified for workplace bullying at that time as exist now in relation to testing, feedback, anonymous complaints. We can actually learn a lot by engaging more with our staff. We can actually lead a lot more by communicating and acting as leaders in this space. The legislative amendments are good. I'm not disrespecting them. I just don't know that they're going to solve all of the problems. As of last month, when we had a Federal Circuit Court judge resign by reason of sexual harassment, where we have had High Court judges, we have had enormous numbers of the legal profession, as I said, we too also need to lead by example. So I think it is an important step to reinforce the circumstances of the seriousness with which we should take it. However, I personally would like to see more around the impact of the proportionality. Our judgments and the awarding of damages are still quite inconsistent. The aspect of just a little bit of sexual harassment, and I kid you not, that issue right now where somebody says, oh, it was only a little bit of sexual harassment. How much is just enough? There was a case in New South Wales a couple of months ago now, not that long ago, $200,000 for perhaps a little bit of sexual harassment, a person who was sexually objectified on a poster. It was unintentional, but it was objectification, and the poster was used and published in the workplace. $200,000, that is a sit up and pay attention amount of money for a poster. And it is a point at which we need, unfortunately, that type of consequence for people to say, enough is enough. You know, it should always be serious misconduct. Proof, as you say, is hard, but that is the unwelcome conduct of a sexual nature.
Okay, and speaking of consequences and maybe looking for that elevated consequence, just a question from the audience, Heidi. Do you think that the anti-discrimination legislation should have a specific duty on employers to prevent sexual harassment? We already have obligations to provide. Sorry, go.
Depending upon what jurisdiction you are in, exactly right. It does already. There isn't a duty to ensure that a workplace is free from harassment and free from sexual harassment will extend to that. There are sufficient protections to be able to require and enforce, and there are penalty consequences, particularly with the reality of workplace health and safety prosecution for failures to address this. No different from workplace harassment and bullying. The issues, of course, is at what point are we going to actually see some of those cases come out before people might actually pay attention and do more? I think Shay would like to add to that too.
Yeah, I don't know how to raise my hand non-virtually, virtually. IRL, raise my hand IRL. But I think what we're seeing from the health and safety perspective is, of course, as Heidi said, the legislation already exists, the obligation to provide a safe and healthy workplace. The regulator previously, though, hasn't either been resourced sufficiently or had the expertise to investigate these types of matters. But what we're seeing now is that they actually have specific divisions and are enforcing the duty of employers to ensure a health and safety workplace, including one that's free from sexual harassment and discrimination, but particularly sexual harassment. So we're seeing a real move from the regulator.
We're all.
So you don't think,
I was just going to add.
And I know we have. So we've got. Oh, look, I am the moderator, people. This is the last time it's going to happen.
I was just going to add in that I know Victoria is has instituted a ministerial task force on workplace sexual harassment, and one of the initiatives that they're proposing is that workplace sexual harassment actually gets reported as a notifiable incident to the regulator from a health and safety perspective. So I think that's an interesting development as well.
I agree, but to Christy's point, how do you prove it and when is it proven? And so at the end of the employer's investigation that we have found that conduct was or was not, or when there is an allegation, and it will give rise and play out, obviously, across the country in different ways. These are all good initiatives that are going to be there to keep it resonating in terms of front of mind for those duties and obligations, which employment lawyers all around here would say have existed reasonably and appropriately, and as Shay said, perhaps not as resourced, but refocused on where it will go for the regulator. I'm seeing for a number of our clients the impact in business of that a complaint might be made to the workplace health and safety area of the business. Do they do the HR perceived to, I think, Hillary's comment before, investigation? Do they do it together? Do they have the resources? What does the enterprise agreement say? What does the employer's policy say? And how we actually look at managing some of these things are throwing up some, what would traditionally just be confusion and flaws in processes, now really necessitating these parts of the businesses to work together to ensure that we are compliant, both with safety, enterprise agreements, IRs and policies.
We can talk underwater and through masks.
So it is clear I have completely lost control of the panel. My topic here is done. But clearly, I think in summary, the answer is obviously there are legislative protections in place already. They exist across a range of different pieces of legislation. I know as well that the Queensland legislation is up for review, and they're looking at whether we enhance duties in the Anti-Discrimination Act. So what I'm hearing from the panel is that it's probably unnecessary, but we may have a safety regulator that didn't have the right amount of teeth, but may now be looking at expanding in that space. But certainly the obligations are there on employers in any event. So that's it. I'm closing the door. Unless anyone has any more questions from the audience on sexual harassment, we can come back to that. But I did want to move. Yes, I did want to move, thank you, to the gig economy. This is how difficult managing sexual harassment is in the workplace. We've seen the difficulties with that just in me controlling the panel. We've seen the difficulties in managing psychosocial risks that Shay has already taken us through. We've seen the difficulties, and we've talked about the difficulties in managing your casual employees, the changing High Court decision, the impact of casual conversion. Shay, with all this going on, what are the chances that an employer or a principal can manage workers in the gig economy, and what tips do you have for them?
Yeah, thank you, Christy. I think that's very difficult, and I know, recently there was a case where, and we've had the inquiry in Victoria into the gig economy, and we've seen a unfair dismissal case, allegedly, according to that inquiry, being paid out $400,000 in settlement for a unfair dismissal that at best could have been worth about $16,000 allegedly, had it gone through. We only know what the TWU presented at the inquiry in relation to that case. It was settled under deed, and I'm certainly not making any comments on that specifically, but it is a vexed issue, and one where we've seen cases go either side. And I guess the point that I think is really worth sort of thinking about is, are we actually, the protections, a lot of these, the gig economy, labour hire, independent contractors, even casual workers, have been set up to manage flexibility in the workplace, but we're seeing the putting of liability akin to employment, and they're talking about introducing regulations to give independent contractors and gig economy workers the same sorts of rights as employees. In the work health and safety space, we're seeing significantly upstream principals being held liable, and I'm not saying necessarily they shouldn't be. We've seen some terribly sad cases in the sort of the Uber drivers of people dying and having no insurance. But we're seeing this sort of move away from, does it really matter if it's an employment relationship? You're going to have the same liabilities and have to give them the same entitlements as if they were. And I think the important thing for employers, and we saw in the recent Coal Board of Inquiry, recommendations that essentially labour hire workers be required to have the same obligations as if they were the employee of the coal mine, and the labour hire company having obligations that perhaps they would normally have management and control over. So we're seeing this real shift, and I think the sit up and take notice to make your point before is to say, well, we actually need to revisit our concept of worker and say, well, what is it that our business needs? We've got flexibility. People are working from all over the world doing all sorts of jobs now. So how do we revisit that to actually understand both our insurance, our entitlements, our safety, our protection from sexual harassment, across the board, no matter how our business is set up or our workforce is set up.
Thanks, Shay. All of these topics that we've been talking about today, they really go, don't they, to our social license to operate, how we manage our employees in the workplace, how we take on board and address complaints to deal with, for example, the sexual harassment concerns. It's all about that social piece of the puzzle, and that brings me to that really fun acronym that we're all hearing these days, ESG. Social is the S in ESG. Hilary, I'm going to turn to you. You bring us home and wrap this all up for us. What is the value of engaging in an ESG platform or program? Are companies failing? What do we need to do? What should companies be doing? And if they can take away, a key message here in this space, what is it going to be?
Thanks, Christy. I think ESG, is really important in the employment and the WHS space. And I think we can just look at recent media, just to see a huge amount of examples of things where, companies are, failing from a reputational perspective at the very least, whether or not, what they were doing was not necessarily illegal. In terms of, you have your Fair Work Ombudsman's underpayment, investigations of significant companies. We've had the commission into the banking industry. I think all of those are examples of ESG, and where I think we are now seeing more and more society more changing and holding businesses to account for things that are not just about the pure letter of the law. And that's really, I think we can see safety incidents come at a significant personal and financial reputational cost, not to mention, of course, the tragedies involved in them. We've seen some really good material coming out. For example, Australian Council of Superannuation Investors actually reports that an important characteristic of outperforming companies is their ability to retain and grow staff. And so I think you can see some of those metrics are becoming more and more important to the future retention of your people and how we engage them and keep them there. Do I think companies are failing in it? I think it's a really complex issue, Christy, and I think that we're seeing, as I said, so many reputational examples. I think we're looking at, when you look at the Banking Board of Inquiry and the Coal Mining Board of Commission, that inquiry that just came out recently, a lot of those examples are, and Dreamworld, I think we can all see examples of where it looks like corporate culture may have failed in sort of almost a short-term pursuit of gain versus long-term interests. I think we're looking at, in the Board of Inquiry, the Coal Board of Inquiry, how they are saying for labour hire workers, we need to make sure that they feel safe enough to come forward and report instances. I think all of that comes to that ESG piece and what can we do about it. And where I think the important part, and some critically, I think the coroner in the Dreamworld said that there's such an ability for the corporate offices of a business to build and grow and build on that culture and bring, to change some of these things. And that's really where I think business can focus, focusing on boards getting the right level of information, the right level of data, and not just meaning more, I'm meaning the right information to be able to critically govern these instances and look at ESG as a whole. I know the S is incredibly important to our hearts as employment and safety lawyers, but I think it's ESG has to be considered as a whole. And I think we're going to just start seeing more and more metrics in that space. And I think if you have a look at a lot of the media, I'll end up here, Christy, I know you're looking at me, but in terms of the Woodside BHP merger that just came out this week, I saw an article that said that one of the key focuses on that engagement with climate change and making sure that both of those companies were able to sort of meet their investors' requirements moving forward. And I mean, we've ended up, as a result of that, it's one of the 10, a company that's going to be one of the 10 biggest energy producers in the whole world, with climate change being a huge driver of that. And I think that that's just really where we're just going to see ESG coming forward more and more.
Excellent. Thanks, Hilary. That was great. And look, we are getting close to wrapping it up, but I think there's been a number of really great takeaway messages that we have coming out of today. Certainly, key things to keep in mind. 27 September, thanks, Haiti, that transitional time frame comes to an end for our casual conversion processes, but it doesn't end there. And when we're thinking about managing sexual harassment concerns or complaints in our workforce, look at that additional guidance that's been provided by Safe Work Australia for those risk assessments and how to identify where those risk areas might be. COVID, can't forget COVID. Let's think about how we are communicating with our workforces in relation to vaccinations. Are we making it mandatory? Do we have a platform to make it mandatory? Are we relying on safety, continuity of supply? How are we addressing that? And if we're encouraging it, Hilary's alerted us to the TGA guidance that's already been released in that respect. If we are promoting vaccination, are we doing that appropriately? We have maybe 3 minutes to go, so I'm going to give you all one top tip, one final comment that you want to make. Keep it tight, people. Haiti, you can go first.
I can't keep to one top tip, as anyone would know, so I'm going to actually give a plug. The plug is for Are You OK Day, which is coming up, and the Workplace Relations team, Laura and I, will be doing our annual Are You OK Day seminar, particularly looking in the current environment. The platform this year is Are They Really OK? Ask them today. With everything that's going on, working from home and the importance of resilience, seminar is the 1st of September. I won't see you there. I'll see you virtually, but I'd really rather be seeing you there.
Okay, so managing psychosocial hazards for Haiti is the way to go. Hilary.
Thanks, Christy. I think we've covered a lot of it today, but really I think the top tip for me is just to really make sure for people that you really are looking at your contracts. I know we harp on about contracts and risk assessments all the time, but if you're wanting to do something with your vaccination policies, if you're wanting to make sure your casual path is on the right track, I really would encourage people to go back and revisit their contracts and make sure they've got their house in order.
I think that's great, and there should be an annual refresh of contracts in any event to catch up on all of these risks as they arise. And Shay, I have not forgotten you. Top tip.
Well, I'm going to say, as Hilary alluded to, I was going to harp on about risk assessments.
Shay.
You can't make any of those decisions, whether it's managing your psychosocial hazards, your sexual harassment risks, or your decisions as to whether or not you can create a mandatory vaccine policy, or even your management of enforcement of masks. They need a documented risk assessment that sits behind it so that you can justify the basis upon which you made those decisions. And that gives you the evidence to support the decision if you're ever challenged, but it also helps with that thinking as you go through, because you know the platform on which you're making that direction.
Excellent. Thanks, Shay. And thank you, everyone, Hayley, Hilary and Shay, for your time today. They will each get some clear written guidance from me for next time about what it means to be a panel member and listening to the moderator. But I appreciate all of your time today as well on the video chat and for the questions that came in. If you have any other questions arising from this, please don't hesitate to reach out to us. You have all our contact details, and we look forward to hearing from you soon. Thanks.
Thank you.
Very great moderation.
Thanks, Christy. Thanks, everyone.